Your continued support of the CryptoQ Media channel is much appreciated. I can now say, a significant victory has been achieved by Ripple in the continuing class action litigation and the XRP Securities case in the Northern District Court of California. The team at Ripple Labs scored a huge procedural victory. In a decision affecting federal and state class actions alleging unregistered securities, the judge in Oakland granted the corporation's move for summary judgment. Despite the closure of the class action case at the district court level due to this procedural success, all parties involved nevertheless brought the claims. Notably absent from this solution is any consideration of Ripple's primary grievance, namely, the classification of Ripple's native cryptocurrency as a security. If XRP satisfies all three conditions of the Howey test, then the court was going to rule on the case. A jury's verdict is necessary for the case to proceed. Despite the expected settlement, this particular claim brought forth by a single plaintiff is scheduled to be considered in court due to the tiny magnitude of the damages and the danger that the jury could decide in favor of the defendant. A key issue with the present regulatory environment for cryptocurrencies is now addressed by this verdict. The decision demonstrates how desperately Congress needs unambiguous laws, according to a legal expert. For instance, the regulatory structure can become fragmented if XRP is deemed a security in California but not in New York. In a post, Ripple's chief legal officer addressed this matter. "Greetings, I am Stewart." Notably, the judge's decision to dismiss all allegations of breaking federal securities regulations is a major triumph. The judge had rejected all charges, he continued. On his view, the decision of the New York court that XRP is not a security is final and binding. Even the final state law claim involving a remark from 2017 was handled by Alder Ot. The allegations state that the plaintiff's loss was minimal, amounting to only a few $100s. Since the plaintiff did not purchase XRP directly from Ripple, the statement may not have had much of an impact on them. "We look forward to that cross-examination," Alderdi said, leaving no room for doubt about his views and promising to deliver. Judge Phyllis J. Hamilton's case 3018-6753 PJ has been the focus of the XRP community's attention for some time. On June 20, Ripple Labs Incorporated announced a significant victory in its protracted legal battles, including the federal class action lawsuit filed in the Northern District of California. Because the case could have far-reaching effects on how XRP is classified under U.S. securities regulations, the outcome could have a significant impact on the digital currency. Judgment by Judge Hamilton allowed Ripples to seek summary judgment, which led to the dismissal of federal and state class actions that had claimed that XRP was traded on social media as an unregistered security. Both the federal class claims for unregistered securities and the state law securities were granted by the judge in response to Ripple's petition for summary judgment. Prominent XRP supporter Fred Rispoli sheds light on how this relates to the Oakland class action lawsuit. Despite Ripple's triumph in dismissing the class action claims, the court did not issue a final legal ruling on whether or not XRP should be classified as a security. These victories were merely procedural. As an alternative, a jury would have to determine whether XRP satisfies the three conditions laid out by the Howey test, which determines whether an asset is a security in the United States. According to Kitchen, this is the truth. The class action has now been resolved at the district court level. Litigation involving the ripple effect appears to be far from over, according to this. As it pertains to the investigation into whether or not XRP is a security, a jury will decide whether the three conditions of the Howey test are satisfied. The court has now confirmed that the claim an individual plaintiff's claim will go to trial. But, the little amount of damages and the possibility that the jury could side with the defendant make a settlement more likely than not. Ultimately, the court has established that the question of whether XRP should be considered a security for retail consumers, or not, will be decided by the jury, not by the legal system. A variety of responses have been voiced by other legal professionals in response to the opinion. A contrasting ruling from Mark Fiegel, an attorney in the cryptocurrency business, has emerged, adding to the intricacy of how the law handles digital assets. Examine the viewpoints confrontation with Taurus on programmatic sales. While Ripple did manage to win on a procedural level, the case would have been more interesting if the court had decided, without consulting a lawyer, that the transactions in issue were, in fact, security sales. The classification of XRP is unknown at this time. The narrow reach of the verdict has been brought to light by Rispoli's remarks. The case involves XRP and the Securities and Exchange Commission's allegations of federal securities breaches. Judge Taurus's ruling hinges on these allegations. Other courts can ignore the case if it has nothing to do with the SEC because it is in the Southern District of New York. To add to that, CBDC and Ripple have announced 10 agreements through Ripple's CEO. Ripple has received some relief with regard to these strategic agreements as a result of the dismissal of the class action lawsuits filed against the company. To this day, however, the bigger legal questions concerning XRP and its possible asset classification have not been settled. An important summary of the key argument, which is that federal law must regulate cryptocurrency systems, will be determined by the jury's verdict about the timeliness of the Howey test's applicability to XRP. Since XRP is on track to be recognized as a security in California but not New York, he believes that the cryptocurrency movement must persist in its call for federal legislation. The verdict in this case shows that a class action complaint has listed Ripple Labs Incorporated XRP AI LLC, and Ripple CEO Brad Garlinghouse as defendants. Digital asset XRP and its promotion and sale are at the heart of the claims in this lawsuit. The legal action stems from allegations that the item was offered and sold without proper registration. Both the question of whether or not XRP is considered a security under U.S. law and the question of whether or not Ripple's sales of XRP to the public violate securities regulations are central to the complaint. Class certification has been granted, allowing the case to proceed as a class action, among other legal procedures that have taken place in this litigation. Thus, in the case of a financial disaster, all XRP holders within a specific time range can be collectively represented. Following the adoption of the first proposed rule under the statute of repose, the court rejected the federal securities claims pertaining to the unregistered sale and offer of XRP. The court ruled that the federal securities allegations could not be pursued as the offering took place more than 3 years before the lawsuit was started. Similarly, the federal allegations were supported by this. There is no further video after that. If you find my channel entertaining, please subscribe. Arriving soon, goodbye.